Hello, my name is Kayla Thomas and I'm an HR advisor at TPC Vision. Today we're going to talk about employee benefits during the COVID-19 pandemic. The title of today's presentation is COVID-19 Employer Benefit Plan Considerations During the COVID-19 Crisis. This recording is being done on April 28, 2020. So if you are watching this recording after April 28th, please note that the information provided in this presentation may be updated. Please check our website for the most up-to-date information regarding the COVID-19 pandemic. As a legal disclaimer, this communication and any accompanying documents are intended for educational and informational purposes only. They should not be relied on as legal advice. While we hope that you learn a lot today, please note that we are not attorneys and the information should not be construed as legal advice. If you are seeking legal advice, you are encouraged to consult an attorney. The purpose of today's presentation is to provide guidance and answers to common benefit plan questions for employers dealing with the COVID-19 pandemic. Today we are going to cover quite a bit of information. First, we're going to talk about the COVID-19 legislation. Second, we're going to talk about benefit plan considerations. Third, we're going to talk about employer health plans. Then we're going to talk about reducing or freezing benefits. And fifth, we're going to talk about qualified retirement plans. And then at the very end, we are also going to review some of the common question and answers related to this topic. Let's talk a little bit about healthcare first. All testing for coronavirus or COVID-19 is to be covered by private insurance plans, fully insured and self-insured without cost sharing. It also allows a high deductible plan or HDHP paired with a health savings account to cover telehealth services prior to a patient reaching the deductible. The new legislation also allows individuals to use funds in accounts such as HSAs and flexible spending accounts for the purchase of certain over-the-counter medical products as qualified expenses. Now, ERISA also was affected by this new legislation. It amends ERISA to allow employers the ability to postpone certain ERISA filing deadlines for a period of up to 1 year. It also gives single employer pension plan companies more time to meet their funding obligations by delaying the due date for contributions during 2020 to January 21st, 2021. Additionally, the emergency leaves were enacted in the new law. It allows employees who were laid off March 1st, 2020 or later to have access to paid family and medical leave in certain instances if rehired by the employer. Please note that under the emergency FML expansion guidelines, the employee would have had to have worked for the employer at least 30 days prior to being laid off. Let's discuss some of the plan considerations. So first of all, service provider contracts. You're going to want to remember to review the terms of your existing contracts to ensure the understanding of the material terms and conditions of the contract. Consider the following. The fees in many administrative contracts are determined based on the number of participants in the plan. A reduction in force or hours that affects the total number of eligible employees could result in increased fees. Lockdowns and work from home requirements could be affected by service providers' ability to meet their contractual obligations. Employers should also consult with their insurance or stop-loss carriers to determine the effects of workplace changes that could result in premium adjustments for the coverage. And then they should also make sure to seek specific legal advice with respect to the navigating the effects of COVID-19 on existing service provider contracts. All right, now let's talk about qualified retirement plans. So, fiduciaries of qualified retirement and other funded ERISA plans should pay attention to their fiduciary duties during uncertain market conditions. The CARES Act permits employers to expand participant access to certain retirement plan accounts for coronavirus-related distributions. Those distributions made from January 1st, 2020 through December 31st of 2020 up to a maximum of the lesser of the participant's vested account balance or $100,000. If your 401k plan permits participant loans, a participant may prefer to take a loan rather than a taxable coronavirus-related distribution. Most plans permit hardship withdrawals in accordance with the existing IRS safe harbor requirements, which would not specifically permit hardship withdrawals for expenses and losses related to COVID-19. Also, many defined contribution plans permit participants to elect to receive in-service distributions if they have reached age 59 and a half. So make sure just to remember all of that information whenever you are reviewing service provider contracts and qualified retirement plans. All right, now let's take a look at employer health plans. Employers should consider the effects of COVID-19 decisions on their employer-sponsored health plans. As a reduction in force or other workforce changes that affect employee eligibility could result in premium adjustments for the coverage. The FFCRA, or Families First Coronavirus Response Act, requires group health plans to cover costs related to diagnostic testing for COVID-19 and related healthcare provider services. Plan or policy terms dictate whether employees who are furloughed or who experience a reduction in hours can maintain their health coverage. COBRA or state continuation coverage may need to be offered to employees who are terminated or who experience a reduction in the hours, making them ineligible for coverage under an employer-sponsored health plan. Employers with an average of at least 50 full-time equivalent employees must provide affordable health insurance that provides minimum value to its full-time employees in order to avoid exposure to an IRS penalty. So many of you are aware of this. It has to do with those ACA guidelines that most of you are probably complying with at this time. Employers who are covered entities under HIPAA and their business associates should remember that HIPAA, privacy, and security rules continue to apply during the COVID-19 pandemic. Employees cannot make mid-year election changes based on a furlough or reduction in hours. So, for example, a change in employment status. With respect to any coverage paid on a pre-tax basis through a cafeteria plan unless the election is consistent with the nature of the event. Let's talk about reducing or freezing benefits. Many employers are trying to be creative and look for new ways for employer cost savings. So, employers looking to reduce operating costs in the short term may seek to reduce or freeze benefits in their defined benefit plans, or reduce or suspend employer matching or non-elective contributions in their defined contribution plans. Freezing or reducing future benefit accruals under a defined benefit plan requires that participants and/or beneficiaries receive a special notice, generally at least 45 days prior to the effective date of the reduction. Discretionary employer matching and non-elective contributions may be suspended or reduced and may or may not require a plan amendment. Although the ability of an employer to suspend or reduce matching or non-elective contributions to a safe harbor plan is more limited and subject to certain additional requirements. Let's take a look at qualified retirement plans. So, the partial termination of qualified retirement plans. A reduction in force of 20% or more of a qualified retirement plan's participant in a particular plan year that is not considered to be routine turnover could result in an inadvertent partial termination of the plan. In the case of a partial plan termination, all affected participants are required to be fully vested in their accounts. Now let's look at voluntary termination of qualified retirement plans. Upon termination of the plan, all participants must be fully vested in their accounts under the plan. Employers should be aware of a special rule which provides that an employer who terminates a 401k plan generally may not establish a new plan within 12 months following the termination. There are some exceptions though. In addition, employers considering terminating a defined benefit plan should consider the effects of recent changes in the markets and interest rates on a plan's funded status, as well as the special notice requirements. Now we are going to move into the Q&A session of this presentation. Question number 1. Are any changes required to your health benefit? Well, the Federal Families First Coronavirus Response Act, or FFCRA, requires group health plans and individual and group health insurers to cover COVID-19 testing without applying any cost sharing or prior authorization or other medical management requirements. This requirement only applies during the emergency periods set by federal law. Question number 2. Do you know what your short-term disability policy covers? Well, while most policies should cover an individual diagnosed with COVID-19, they often will not be available for individuals who are quarantined, even if under the mandate of a federal, state, or local law. Some disability policies also contain exclusions for conditions acquired during business-related travel. Employers may want to amend their short-term disability policy to expand availability related to COVID-19 by taking measures such as including quarantine as a disability or allowing individuals to self-certify a condition during a public emergency declared at the state or federal level. Alternatively, employers may want to implement standalone temporary COVID-19 policies that supplement existing paid leave and disability programs. Question number 3. Are you taking advantage of cost-sharing waivers and telemedicine benefits? The Internal Revenue Service, IRS, announced that high-deductible health plans may cover testing and treatment of COVID-19 on a first dollar basis without requiring any cost sharing such as co-payments or out-of-pocket spending up to the deductible. The IRS confirmed that plan amendments fully cover COVID-19 testing and treatment will not disqualify health savings accounts eligibility. Please note that the IRS notice covers treatment which is not required to be provided without cost sharing or medical management under the Federal Families First Coronavirus Response Act. Some insurers will waive all telemedicine fees, including for visits unrelated to COVID-19. This is partially due to the Centers for Disease Control and Prevention encouraging the use of telemedicine services to help prevent the spread of the virus. And it is partially due to the administrative difficulties in determining which telemedicine services relate to COVID-19. While state insurance laws do not apply to self-funded health plans, employers may want to discuss the possibility of temporary fee waivers with their telemedicine administrators, as well as cost-sharing waivers for the testing and treatment of COVID-19. Question number 4. Are you reducing employees' working hours? Many employers have needed to reduce working hours in response to the COVID-19 emergency. There are several benefits ramifications that employers should be aware of for their plans. Most employer health plans limit eligibility to employees who work full-time as determined by the ACA rules. If employees lose health coverage because of a reduction in working hours, their right is consolidated to COBRA continuation coverage or state continuation coverage will be triggered as applicable. This may not happen for a while depending on the measurement method and stability period that the employer uses. Employees could lose eligibility for other hours or status-based benefits as well. Employers may want to consider amending benefit plan eligibility to avoid this result. Even if employees maintain eligibility for benefits despite a reduction in working hours, employers with 50 or more full-time equivalent employees could be affected by ACA rules regarding affordability and applicable large employer status. Employers may also need to consider furloughs, paid or unpaid, which have a similar benefit plan considerations. Question number 5. Does your 401k plan offer hardship distributions or loans that may apply to COVID-19? Many 401k plans offer in-service distributions to participants who suffer financial hardships. One type of hardship withdrawal allowed by the IRS is for medical expenses for the plan participant or their primary beneficiary under the 401k plan. Because the President declared COVID-19 a national disaster, some participants may also qualify for disaster-related distributions. 401k plans generally do not limit the circumstances under which participants may take plan loans. For 401k plans that allow plan loans, however, some plans place limits on the number of loans that can be taken out of the plan at any given time or on the amount of the participant's loan. Under IRS regulations, employees who are on unpaid leaves of absence under 1 year long may forgo loan repayments if certain conditions are met. Employers that need to reduce their workforce may also want to consider amending plans to allow loan repayments to be made through withholding on severance payments. Employers that do not permit 401k loans may want to consider amending their plans to add them. Question number 6. Are your severance and executive compensation agreements affected by furloughs? Employers should carefully review the terms of their executive compensation agreements. While furloughs will generally not be considered a separation from service, some agreements contain a payment trigger for good reason, such as a material reduction in compensation or benefits, a change in work location, or a material diminution in work responsibilities. Severance payments triggered by a furlough could negatively affect an employer's cash flow and could also trigger state unemployment benefits. However, employers need to be careful to avoid any impermissible accelerations of deferred compensation that may occur by amending executive compensation agreements. Question number 7. Do you have employees teleworking in different states? Employees who work remotely must report income to the state in which they are performing services. This will be the state of residence for employees teleworking from home. Employers should coordinate with their payroll tax providers to correctly report the income of their teleworkers. This is not applicable to temporary teleworking arrangements. If the employee is temporarily working remotely due to COVID-19, then you would continue to report their wages to the state in which they normally worked prior to the temporary teleworking arrangement. Number 8. Are you terminating employer or employee contributions on account of COVID-19? Employers should determine whether any changes can be made to contributions towards benefit plans. School and daycare closures may affect the eligibility of dependents for dependent care flexible spending accounts, allowing employees to change their contributions mid-year. Employees who qualify for leave under the Family and Medical Leave Act must be given the option to revoke or continue health plan and FSA coverage. Employers may also be able to discontinue 401k discretionary non-elective or matching contributions. Safe harbor plans will require a supplemental notice 30 days in advance of the suspension of contributions. Employers may only discontinue mandatory matching contributions by amending the plan document. Question number 9. Have you considered benefit plan options for aiding employees during this emergency? Many employers have had to reduce employee hours and workforces and are interested in affordable measures to boost employee morale. Employers can review options including supplemental unemployment benefit plans, emergency sick leave policies, COBRA, and employee leave programs. If employees have lost health plan coverage due to termination or a reduction in hours, employers may choose to partially or fully subsidize their COBRA premiums. Employers with self-funded health plans need to be careful to not subsidize premiums in a way that favors highly compensated employees. The IRS has created disaster relief sharing and catastrophic leave sharing programs in which employees pool and share leave time. While COVID-19 conditions may qualify for a catastrophic leave sharing program, they are more likely to qualify for a disaster leave sharing program. The IRS allows employers to make certain qualified tax-free payments directly to employees affected by disasters declared by the President under the Stafford Act, such as the COVID-19 pandemic. Please reference any sources listed here for additional information. As I mentioned in the beginning of the presentation, my name is Kayla Thomas. I've been a part of the TPC team for 4 years. I graduated from Missouri Southern State University with a Bachelor of Science in Business Administration with an emphasis in accounting, business management, and human resource management. I also have a master's degree in human resource development with an emphasis in management and consulting from Pittsburgh State University. I also hold my SHRM Senior Certified Professional Certification, and I am a Certified DISC Communication Consultant. As you can see here on the screen, my 2 team members are Angelique O'Brien and Stephanie Cumley. I would like to say thank you so much for your attention today. I appreciate you listening to our presentation. Please contact the TPC Vision team should you have any questions regarding the content outlined in this presentation. For pricing regarding TPC Vision services, please contact your sales representative. As I mentioned, TPC Vision provides HR consulting to TPC Vision clients. Thank you guys so much and have a great day.